on what was in the bill as it came to Select Committee. Thank you.
I call the Honourable Member Eugenie Sage. Tēnā koe.
Tēnā koe, Mr Chair. Thank you. I would like to correct some of the statements that Jackie Dean made. I think she was more than mischievous in not accurately characterising the Green Party's position on this bill. We supported the bill at its introduction because there is a huge gap in the environmental management of our oceans, the fact that we don't have legislation which provides for a consenting regime. But we have opposed it and continue to oppose it because of the major shortcomings of the bill, the fact that there is no hierarchy for matters of national importance, the fact that treaty obligations are not well dealt with, the failure to adequately provide for the protection and preservation of the marine environment in line with the UNCLOS. But in relation to this part, Mr Chair, Part 3 of the bill is about what can happen after the Environmental Protection Authority makes a decision. It relates to objections to the EPA's decisions, appeals to the High Court and beyond on points of law and enforcement. And Mr Chair, it's this fact that there are no appeals to the Environment Court and that you can only appeal, well, submitters and applicants can only appeal to the High Court against whole or part of an EPA decision, that is a major issue. Because that's denying access to justice, not having the full scope of appeal rights to the Environment Court. And it's meaning, well, not denying, it's constraining access to justice. And this was a deliberate policy decision by Cabinet, and we understand that it was because Cabinet believed that the EPA was already making decisions at the national level and was seen as being an expert body. But as the Forest and Bird Protection Society noted in its submission, Clause 97 of the bill provides for applications which deal with nationally significant cross-boundary issues, that's across the 12 nautical mile limit, to be dealt with by a board of inquiry, not by the EPA. So surely, Mr Chair, this is already signalling that the EPA does not have the same standing and expertise as other decision makers, the fact that you get this delegated to a board of inquiry. So, Mr Chair, the Green Party supports the Supplementary Order Paper 95 in the name of Charles Chauvel because it would provide for appeals to the Environment Court instead of restricting it to the High Court. And, Mr Chair, the experience with the Environment Canterbury Temporary Commissioners legislation is instructive because that legislation has disallowed appeals to the Environment Court and restricted them to points of law appeals to the High Court. Environment Canterbury has just notified decisions on the Canterbury Regional Policy Statement. There has been a slew of appeals from various parties, technically on points of law, but a lot of those appeals actually raise substantive issues of public policy around environmental management and, in that case, the appropriateness of policies in the Regional Policy Statement about whether they're adequate to control the allocation of water. So those sorts of public policy, public interest issues are much better dealt with by the Environment Court, given its specialist expertise, given the substantial technical skills of the commissioners who sit alongside the judiciary, and given the court's experience with mediation such that a lot of cases are resolved before going to a formal court hearing. And I think the downplaying and setting aside of the role of the Environment Court in this bill is very short-sighted because it means that the focus is going to be very legalistic in the High Court, where you don't have that specialist expertise that the Environment Court has. And, Mr Chair, I think we need to reflect on the fact that the Environment Court succeeded the Planning Tribunal. It has dealt with and been fundamental in developing the case law around particular bits of the RMA, the meaning of particular clauses, the legislation there. Similarly, this bill and the substantive issues about how our oceans should be managed would benefit from the Environment Court's expertise in allowing for appeals to be taken there. And, Mr Chair, the Environment Court's also much more accessible than the High Court to lay people. So by restricting it to the High Court again, you're constraining the ability of communities to engage. And the Environment Court is not bound by strict rules of evidence. It has the powers of inquiry, which when you're dealing with public policy issues like resource management, management of the oceans, are very useful. So given the substantive public interest issues that will come up in appeals, in our view, Charles Chauvel's SOP should proceed because it reinstates those appeals to the Environment Court. And I think doing it, Mr Chair,
I call the honourable member
doing away,
Eugenie
thank you, Mr
Sage.
Chair, doing away with